And I'm going to recall to order public meeting number 131 of the Massachusetts Gaming Commission, and we have one item left on the agenda, and that is, excuse me, Region A. And the first item on that general topic is the extension of transportation plans comment period. Mr. Ziemba, I think the first two at least are yours, so.
Good afternoon, Commissioners.
Good afternoon.
So as you know, we recently had a comment deadline of August 1st regarding the transportation plans that were delivered to us on June 20th, I believe. We did not receive a significant number of comments for that comment period. There's been some interest in asking us to extend that comment period. So I'd recommend that we extend it by at least a week, if not perhaps into the week of the 12th of August, or excuse me, the 19th of August. That would give folks some additional time to provide comments to us, but it would get comments to us hopefully in time as we are completing our reviews prior to the anticipated decision week.
So these are the transportation plans that the applicants presented to us on June 20,
Yes,
and that are they're posted on our website.
that's correct.
I was just taking this out to look at a calendar. What is would 2 weeks from tomorrow be too late? Do you think to extend that comment period?
No,
2 weeks from tomorrow would be the 21st, right? 22nd.
We have a meeting scheduled for the 21st.
Yeah.
Yeah, but in terms of trying to incorporate those comments into our evaluations and the like that we present at the meeting that'll begin, the hearings that'll begin on September 8th. Does that make thoughts about that?
I think, you know, extending the comment period is very easy for us to do. There's things that still come in the next few days. I suspect there's still those milestones, right, relative to the final EIR and the draft EIR, et cetera. So yeah. I think it does nothing but good. There's no harm.
Have to hustle at the end to incorporate.
Right.
Deadlines,
Right.
yeah.
Well, we're encouraging people to get the comments in as soon as we can. The sooner we get them, the better we can digest them. But at least for those who for one reason or another may not have the wherewithal to do so. So let's extend the comment period then till the 22nd of August.
Great.
And
Great.
the instructions are on the website as to how to get the comments to us, and we'll continue to read them carefully as they arrive.
Great.
Okay, item B.
Commissioners, over the last week, we've met with representatives from the Metropolitan Area Planning Council, MAPC, and with a number of individuals and groups from Charlestown. MAPC has been preparing a memorandum for the Commission analyzing the relative strengths of both applicants and concerns. As I previously reported, we informed MAPC that its review could also be useful to us in our current review on any conditions that could be placed on the WIN license if WIN is successful in receiving a license from the Commission. We received this memorandum last evening. We can share that memorandum and any responses to it on our website. We already have posted the PowerPoint of our meeting with WIN on its best and final offer on our website. That's been up for some time now. In general, in addition to a number of strengths for both applicants, the MAPC review describes how the WIN plan could impact the planned improvements on the Rutherford Ave Sullivan Square corridor. I just want to thank the MAPC for their review. They have been very interactive with us throughout this whole process. All of the regional planning agencies have been assisting us through this whole process, and I wanted to thank them for their very thoughtful review. In addition, we had a very productive meeting with a cross-section of Charlestown residents, and have spoken with others such as the Charlestown Mothers Association. A number of groups were represented, such as the Charlestown Neighborhood Council, Charlestown Preservation Society, Charlestown Waterfront Coalition, Rutherford Ave Sullivan Square Advocacy Group, Gardens for Charlestown, Friends of City Square Park, and the Rutherford Corridor Improvement Coalition. In addition to a number of citizens that have had a historical role in the debate related to the Rutherford Ave Sullivan Square plan. We thank them all for a very productive meeting about potential conditions. Written comments we received prior to and during the meeting are included in your packet. We are in the process of putting together a summary of the meeting. However, many of the main points that we heard can be found in the letters that are in your packet. In general, recommendations were made that the WIN licensee, if WIN is chosen to be the licensee, should pay for or pay a significant share of the costs of the planned Rutherford Ave Sullivan Square plan, particularly the Sullivan Square portion. There was some debate about the efficacy of the Rutherford Ave Sullivan Square plan to address future traffic, even without the addition of the WIN project. Comments were received that noted that WIN's FEIR submission does not measure against the future planned Rutherford Ave Sullivan Square plan. There was also some commentary on how the traffic measures proposed by WIN for the current rotary will pose some difficulties on areas such as the Main Street intersection with the rotary. Several commenters positively mentioned WIN's focus on prioritizing alternate transportation plans to remove vehicles from the Sullivan Square rotary, and they mentioned the importance of ensuring that such goals are realized. We are very grateful to the thoughtful input we received. We noted that we are trying to find as fair a result as possible, fair to the residents of Boston, fair to the city, fair to both of the applicants, fair to the two Region A communities that went through arbitration, and fair to the Region A communities that reached an agreement with the Region A applicants. We are currently reviewing information including the hundreds, if not thousands, of pages of relevant documents already assembled, and are working to get further information that will help us in our review.
All right, thank you for that succinct and thorough report. Comments, thoughts?
How many folks did you have turn out at the hearing or the meeting you had the other night?
It was meant to be a dialogue. There were approximately a dozen.
But the dozen were people who had been active for a long period of time and represented groups that had been active for a long period of time in the planning efforts and in the community.
That's correct.
Yeah.
And in addition, we have a public hearing that is scheduled, 2 public hearings that are scheduled for next week, where undoubtedly we'll receive additional input from a number of those groups and other citizens from Charlestown,
Right.
Everett, and other places with the stake in this matter. As we know, this is a regional concern with Everett, Somerville, Chelsea. So a number of communities, I'm sure, will provide helpful input on both of the applicants' plans.
When is that happening, or tentatively?
So August 11th and August 12th are our 2 host community
Oh, of course.
hearing sessions.
I think I should be there, right?
I hope it's on your calendar,
I
Commissioner.
don't know.
I will send
I
you
thought
send a
You thought
reminder.
you were adding another meeting to the calendar.
I did. I actually thought you were adding another meeting. No. I will be there.
Right. Commissioner Cameron, any thoughts?
No, it's, for me, I'm looking at these issues, so I've had many conversations with our ombudsman as these comments come in and as he attends meetings, so I want to thank him for representing us well.
Yeah, these the comments, I've taken a quick look at the comments, I want to go back to them, were thoughtful and detailed, as was the MAPC report, which I also have to take a deeper look at. But at first approach, it was likewise thoughtful, comprehensive. And this is pursuant to our obligation, as we mentioned before, to do the information gathering that's necessary to think about and ultimately discuss and adopt conditions on the licenses we issue, whether we issue to Mohegan Sun or to WIN. the specifics you're talking about are designed to help us think about, formulate conditions if the license goes to win. So this is part of our ongoing effort in that regard. We will post the comments from Charlestown are in the packet. What is the plan for the MAPC report?
So we'll shortly post that. The WIN PowerPoint that I mentioned is already on the reports section of our website.
Right.
And it's likely that we would post the MAPC report also on that reports section of our website, and comments that we've received regarding that report and/or the WIN PowerPoint. We'll include that in a section. Perhaps we might consider, again, going to web design, but perhaps we might think about having another section that's dedicated to these matters.
Is there a process for soliciting comments to the MAPC report or to the comments from the Charlestown group that we post, or is this simply part of the general solicitation of comments with respect to the transportation plan?
I think I would incorporate them in the general solicitation of transportation comments. It seems to work well. Maybe we could modify a request for comments as part of that.
Might be worthwhile, yeah.
Well,
Commissioner?
are you suggesting comments on comments?
No, comments on,
You would-
well, yes. I mean, the whole issues discussed in
Right.
the comments are, that we received from the Charlestown groups, for example, are proposals, basically. And I don't see why we couldn't ask other people to comment on those if they wanted to do that. The MAPC report deals with matters broader than traffic.
Correct.
And
Right, sorry. Yep.
we have in the past asked for comments on virtually everything we've received comments on. So somehow, it seems to me it'd be worthwhile to have comments on the materials we post up until
Right.
the end of,
Well-
up until the 22nd.
So long as the relevant materials are, easily accessible, and they are, or we can ensure that they are. Anybody can read it and comment on any one of those aspects and materials.
And we've had some initial conversations with the WIN applicant about how they would provide responses to all of these comments. Obviously, that is a very important part of our review, and I think we'll try to make recommendations of whether or not they respond at the end, or if there are batches of comments that they should respond to along the way. We'll have further discussions about that.
All right, so you'll work that out with them directly?
Correct.
Yeah. Okay. Anything else on that topic? All right, now, as we've mentioned, we have the meetings next Monday and Tuesday, which are designed to hear the final comments in the statutorily required hearings, host community hearings, and bring those hearings to a close so that we can continue with the next step of the licensing process. And in connection with that next step, we have the issue of the city's election not to participate in the surrounding community agreement process that our regulations, for which our regulations provide. And we need to have some advice as to how to deal with that, and we have some advice as to how to deal with that. So let's turn to council for that advice. Mr. Grossman.
Thank you. Good afternoon, Commissioners.
Good afternoon.
There were a number of legal implications that arose when the City of Boston declined to participate in the arbitration process leading to the surrounding community agreement. And as we look to clear the way towards your ultimate decision in the Region A licensing process, it's important at this juncture that we address this surrounding community issue. There are a number of governing statutes that control this issue. The first is Section 15, Paragraph 9. That's the memo that was included that outlines these issues.
That memo's in the packet for everybody to see and look at.
It's in the packet, so I'll hit some of
Sure.
the high points,
Sure.
if I may.
This is really for the people watching at home.
Okay.
It's in the packet and it'll be posted on our website.
Section 15, paragraph 9, essentially sets out a number of prerequisites that applicants must meet in order to be eligible to receive the gaming license. And one of them, and the one that's relevant in this particular case, provides that an applicant must submit signed agreements between it and the surrounding communities. The corollary to that is that if it does not submit signed agreements between it and the surrounding communities, that it is ineligible to receive a gaming license. As it applies in the present situation, where the City of Boston and Wynn are not presently engaged in the arbitration process or negotiating towards an agreement, if the City of Boston were allowed to maintain its surrounding community status, one could argue, and we would suggest, the case would be that Wynn would be ineligible to receive the license. So ultimately, our recommendation to you, and I'll hit a few other points as well, is that the City of Boston be deemed to have waived its surrounding community status for this purpose. There's a companion provision to paragraph 9 that I just referenced in section 17 of chapter 23K, and that's section A of section 17. And that essentially lays out the process by which surrounding communities are determined by the commission. And there are a couple of important provisions contained in section 17A. The first essentially provides, as it discusses reaching a surrounding community agreement, that once the commission determines a municipality to be a surrounding community, then no action may be taken on an applicant's application until an agreement is reached. In this case, the argument would be that you can't take action on an application, the Wynn's application, where it hasn't reached an agreement with the City of Boston while it maintains its surrounding community agreement. There's a second important provision of section 17A, and it's contained in the final sentence of that, and it essentially gives the commission the authority to come up with a process in the event that a municipality that's been designated a surrounding community and an applicant are unable to reach an agreement on their own. A so-called a stalemate has arisen. The commission then has to come up with, and it has come up with, protocols and procedures to resolve that deadlock. And in fact, of course, you did that when you promulgated 205 CMR 125.06, where we came up with the protocols and procedures for the resolution of such a stalemate. Ultimately, of course, the regulations require that the parties engage in an arbitration process that we're all familiar with at this juncture. And the intent of that, and this is the important part, was to ensure that a community that's been designated a surrounding community is not invested with so-called almost a de facto veto authority over an application. The legislature set out an instance in which it felt like a municipality should have veto authority, and that was, of course, in the host community context, where it provided that, again, under Section 15 as a prerequisite to getting being eligible for a license, that an applicant had to submit a positive vote from a host community election. And that, in essence, gives that host community veto authority over an application. The legislature did not grant the same veto authority to surrounding communities. In fact, it did the opposite, and it included that language in Section 17, paragraph A, that essentially invested in the commission the authority to come up with procedures and protocols to break a deadlock. That is, to prevent any veto. The problem here would be if the city of Boston were to be allowed to maintain its surrounding community designation and not participate in the arbitration process to resolve the deadlock, it would essentially be granted the de facto veto authority that Section 17A and the Commission's regulations were designed to prevent, contrary to the intent of the legislature. And the way they would get there would be that Wynn would be unable to submit a surrounding community agreement and would effectively be ineligible under Section 15, Paragraph 9. So for those reasons, we are recommending that the Commission deem the City of Boston to have waived its surrounding community status. We have a provision in the regulations that allows for that and specifically addresses a situation in which a municipality fails to participate in the surrounding community resolution process. And it provides for waiver of the status in this type of situation. It's important, though, to bear in mind that by deeming the status to have been waived, it does not suggest in any way that we lose sight of the proximity of the project to the City of Boston, or that folks who may be impacted by the project lose their seat at the table, or anything of that nature. The Commission would, of course, maintain its stated obligation to ensure that any known impacts are mitigated. And this decision, if this is the decision you were to make, would not affect that in any way, shape, or form. Furthermore, we are suggesting that the Commission could state an intention to leave open the possibility at some point for certainly Wynn and the city to enter into an agreement and for the Commission to accept that as a surrounding community agreement, or for the city at some point to even repetition to be designated a surrounding community. And I think that basically outlines our recommendation.
Well, that's very helpful, and your memorandum is very thoughtful. One thing that I'd like to do before we talk about the implications of this is to put up on the screen, if we might, page 4 of that memorandum, and particularly the section from the regulation that's up above there, not right there, that's good, which provides that in the event a community designated a surrounding community fails or refuses to participate in the arbitration process set forth in the relevant regulation, the Commission may deem the community to have waived its designation as a surrounding community, provided that the Commission may nevertheless impose as a condition on any Category 1 or 2 license a community impact fee and any requirements it deems appropriate requirements for mitigation of impacts from the development or operation of a licensed gaming establishment. That's the regulation to which you were referring, Mr. Grossman. So that is a regulation that, if I understand you correctly, was designed to implement the provision of the statute that said that the Commission has to create and promulgate protocols for resolving an impasse between a surrounding community and a applicant, and provides a mechanism for dealing with situations in which one side or the other, in this case the surrounding community, elects not to participate in the protocols that the Commission has promulgated, and thereby creates potentially the kind of impasse that prevents the applicant from going forward. Is that a fair summary of what that regulation is designed to do?
That's exactly right.
Yeah. And that gathering of information designed to think about, discuss, and ultimately promulgate conditions is the process that Mr. Ziemba has been part of, and that we have heard a report about just minutes ago. So with that as a background, comments from commissioners?
It would appear to me that that's a prudent step for us to take. It's clearly laid out in this memo what the implications would be if we didn't do this, and also the fact that we are not precluding in the future any kind of an agreement if that were to happen. And the piece about conditions, I know that I am working on mitigation, and we take this very seriously, and we're really looking at every impact. So this, to me, would be a prudent step for us to take.
Other thoughts?
We sent a communication off to the city of Boston with respect to the implications of de-designating them as a surrounding community. Did we have any feedback or response from?
We did
City
not
of
have any
Boston?
feedback, but we did send a communication, and we did strongly encourage them to continue discussions. We also, as stated in this memo, encouraged them that if they did finally reach an agreement, we would certainly consider that. So we did send them that letter earlier this week.
And they, the city, in its notice to us that it was electing not to participate in the arbitration process, cited this regulation, did it not?
They did, yes, it was in their letter.
Right. So this is a step that clearly they took with an understanding of what was likely to follow.
Yes, I agree. And not only that, there's been ample time since this issue first surfaced to have, the city done things, differently if they wished to have done that. And it would appear to me that that's not, at least as of now, their intention. So I would concur with the argument as laid out here that from a technical standpoint, we ought to consider this in order to continue our review. And as our regulations and the statute intended, we have a lot of flexibility relative to imposing community impact fees and conditions, to reflect the impacts of potentially this operation.
What are the practical impact, the short-term practical impacts of this? It occurred to me that there were just a couple. Could you help with that?
The short-term impacts of deeming it waived.
Deeming it waived, yeah.
As we outlined a little bit in our letter to the city, we talked about certain benefits that aren't available to a community that's not a surrounding community. It will mean that in the interim, the commission will look a lot more closely at impacts and what needs to be done. It will require some discussions about conditions that are particular to this particular surrounding community. I think that's the short term. Longer term, we'll have to see how it all plays out.
I was thinking more concretely, and correct me if I'm wrong, that the two main impacts, short term, are number one, a city or town that's not a surrounding community doesn't have a right to be heard at the statutory hearing. They're not a party to the statutory
That's
hearing.
correct, yes.
But under our regulations, well, not under our regulations, I guess, but under our practices, we've opened up those meetings to anybody that wants to talk, and we'd welcome the city's appearance to talk at next Tuesday's meeting in Everett if they choose to do so. So as a practical matter, they don't surrender that right. The other practical input, the other practical impact is that they don't have the right to a surrounding community agreement, but they have already said that they don't want a surrounding community agreement. So that one is not adversely affected by this. In the letter, can you explain again what you said about future agreements and the like?
So in our letter, we strongly encourage the city to either recommence negotiations and discussions with WIN or to even, first of all, let us know if they had particular impacts that they
Right.
wanted us to understand.
Right.
But we did make very clear that if in the event they came to an agreement in the future, we would certainly bring that to the commission, so the commission could consider that, consider it as a surrounding community agreement, as a formal surrounding community agreement, if that were the request. We suggested to them, too, that they could, as Mr. Grossman's memo outlines, re-petition to be a surrounding community, and the commission would consider that as well. So we've left the door open to some sort of a negotiated, mutually agreeable agreement between the parties to come back before the commission.
Yeah, it seems to me that the reality, the clear reality is that nothing can work under either of these applications unless a number of people agree in making the outcome happen. And the city of Boston is an important ingredient of making a reality whatever application we grant. So sounds to me like what you told the city simply reflects reality and indicates on our part certainly a willingness at any time to facilitate that reality and help it move forward, regardless of the direction in which we go with respect to a license. Do we have to do this, what do we have to act on the waiver? And it is a deemed waiver. It is a consideration that they have elected not to participate, and participation was a key to maintaining surrounding community status, so they've waived that. That's what the regulation provides. Is there what's the thinking about whether we ought to do this now as opposed to sometime later in the process?
I believe it's been the commission's practice, for starters, to not conclude a host community public hearing until the surrounding community proceedings have been concluded, for starters. And I think there are a number of reasons for that, one of which is to afford any actual surrounding community an ability to have an understanding as to what the agreement is, the mitigation agreement, the terms of the mitigation, et cetera, prior to having to come before the commission to present the testimony at a public hearing. So from that perspective, it would be helpful to do that now, prior to the host community public hearing being closed. Otherwise, I think the only timing requirement is that it be done prior to a decision being made as to which applicant to award the license to, so that you have a completed application before you.
But as I hear you, your first point is that there is an implication, at least in the statute, that's morphed, if you will, into commission practice to complete the surrounding community proceedings before closing the hearing so that the applications are complete
Right.
by the time the surrounding community hearing is closed. So,
That's
so
right.
that would militate in favor of doing this now and acting on this piece now. Okay. Any other comments that either of you would like to make? Other comments from the commissioners that would be helpful, do you think?
I don't see a reason why we wouldn't take this action now, frankly. They've had ample opportunity, meaning the city, to respond. They've been notified. They mentioned this action in their original notification that they would not participate. So I don't see a reason not to proceed in this manner.
I don't either, and I think especially when we take into consideration what's suggested here, well, which is they can always come back and ask to be redesignated. They can always continue to negotiate and reach an agreement. It does not necessarily have to be this surrounding community agreement, but it could be a mutually agreed agreement, and we could consider that at any future time. So I would emphasize those points, which are, I think, very important for the city and the applicant, obviously. But I would agree that I don't see any need to postpone is, and by the same token, we're ready for our closing, as we have currently planned it, our host community hearing next week.
Yeah, I think those points are, I'm sorry, Commissioner Stebbins, did you want to say something?
No, I would just simply, I would concur. I think what only issue I would want to address is, while we encourage both parties to continue to negotiate, that in the long term, there is also obstacles for the city of Boston if they do come to some type of an agreement. They don't find themselves eligible to apply for community mitigation funds. They also do not find themselves eligible to be part of the, I think they have a designated spot on one of the advisory committees as well. So that's obviously not something that impacts them in the immediate future, but long range is something that the city of Boston should be mindful of. And again, I also hope that, both parties would continue to try to negotiate and come to some type of an agreement and come back and petition us at some point.
Well, I just would like to jump in and say that I think we ought to reserve judgment on eligibility for mitigation funds. I think
right.
there is, we have not yet promulgated regulations in that regard. We need to promulgate those regulations, and so I think we ought to put that one to one side.
Okay.
But the general point is appropriate. I think it's really important for a couple of things to be clear. Number one, this simply affects the Everett Wynn application. Doesn't have anything to do with the Mohegan Sun Riviera application. So city maintains its surrounding community status. It's got a surrounding community agreement in that direction. This is simply focused on the Wynn Everett application. Second, we've said it now several times, the city and Wynn are encouraged to continue to reach agreements. Ultimately, working together is the only way this is going to get done. If the license is awarded to Wynn, and the commission is ready to facilitate any agreements that, in fact, arise. And those are important considerations to keep in mind as we move forward. This is more than a technicality, but it is not the kind of door-closing exercise that is dispositive, really, of anything. But it is an important step to allow us to move forward. So with that in mind, I would entertain a motion that the commission deem the city of Boston to have waived its surrounding community status with respect to the application for a Category 1 casino license filed by Wynn Mass LLC.
So
I'd
moved.
entertain such a motion.
So I was prepared to make that motion, but I think you made it, you articulated it well. So moved.
Second.
Is there a further discussion? All right, all in favor?
Aye.
Aye.
All opposed? None? The ayes have it unanimously. All right, is there any other business before the commission?
No.
Commissioners, colleagues? All right, then I'll entertain a motion to adjourn.
Move to adjourn.
Second.
All in favor?
Aye.
The ayes have it. The commission meeting is adjourned.